अस्सलाम वालेकुम फहद भाई।
वालेकुम सलाम। कैसे हो आप? अच्छा
शुक्र अल्लाह
जुरैन,
का।
ये रिकॉर्ड हो रहा है तो मुझे लगता है।
हाँ हाँ।
अच्छा, ये फिर कट भी हो जाएगा, ठीक है। कैसे हो आप, ठीक हो?
शुक्र अल्लाह का, आप ठीक है?
जी जी जी, बिल्कुल। अच्छा, इनको मैंने बोला भाई 8 ही आ जाएंगे, ठीक है।
ठीक है, कोई बात नहीं, अभी वेट करते हैं।
ओके।
मुझे लगता है और हम थोड़ा वेट करेंगे तब, जब तक ये लोग ज्वाइन करें।
हम्म, ठीक है। अब ये भी नहीं पता है ना कितने ज्वाइन करेंगे, यूजुअली तो कुछ हम 5-10 के साथ भी शुरू कर लेते हैं।
हम्म।
Good afternoon, Mr. Fahad. Assalamu alaikum to everybody
Well,
whosoever has
sir,
joined.
वालेकुम अस्सलाम।
I
welcome.
think
Yes, I think sir has joined us now. So a very warm welcome to everyone, and especially Mr.
please continue. Yeah, thank you.
Gupta. So, before starting with this lecture, I want to first of all thank Mr. Vijay Gupta for joining us at a very short notice. And for today's context, our topic would be trademark protection and its importance for businesses. Now, the importance for businesses has been touched upon or selected because businesses, our work as lawyers or legal consultants, largely depends on the market, and market is driven by business. So if we understand what the importance of patent law, trademark laws, or for that matter, other IP rights law based laws as well, is for the businesses, we would be better able to deal with the demand in the market, so to speak, in the legal market, and that would help.
सॉरी टू इंटरप्ट यू फहद भाई,
Yes,
बट यू आर नॉट, आपका कैमरा, यस।
yes. So the importance, yes. So where was I? The topic is trademark protection and its importance for businesses. Now, again, I want to cut myself short here by saying that if we understand where the supply is in this legal market, it would help us, especially being young lawyers. It would help us, young lawyers, to understand what their focus areas are and how they can sharpen it. So we have with us a very distinguished advocate who deals with intellectual property matters. Mr. Gupta is stationed in Delhi, and he has worked both at the Delhi High Court as well as different district courts in Delhi, and the Supreme Court of India as well, where he deals primarily with IP law related matters. So, without further ado, I would invite Mr. Vijay Gupta to kindly deliver his lecture for today. And we'd also appreciate if the audience at the end of the lecture engages with Mr. Vijay Gupta to make full use of his vast knowledge and experience, and by that, take full advantage of it as well. So, Mr. Vijay, I request you to please start your presentation, sir.
Good evening, everybody. And thank you so much, Mr. Malik, for inviting me for this lecture on this trademark and its aspect on business. You have rightly mentioned that it is a quite complex and quite critical issue nowadays in the competitive market. There are, we every day heard that there are lots of dispute regarding the infringement of trademark, piracy, passing of the trademarks. So, and it is, IPR is not a new subject. It is quite old, long practice. But now in this today's age in the competitive market, it is quite significant because in the past time there were no effective protection with regard to the violation of trademark, copyright, passing of the trademark, and not only lawyers, because this is a different aspect. Generally, the practice relate to civil matters, criminal matters, labor matter, corporate matters, but IPR is quite different. And IPR include 4-5 aspects. Trademark is one of them. This one is the trademark, copyright, patents, and industrial design. These are the basic 4 aspects of IPR. Mr. Malik, could you please permit me to show my the presentation slides?
Yes, sir. Yes, sir. Definitely. Definitely, sir.
I think I'm not having access to this.
Access. I will try to grant access, sir.
Just a second. I'll just do it. You might be able to do it, sir.
Yes. Thank you. Yes, now I can see. Yes. So we are discussing trademark here, but let me start with the beginning. This is called intellectual property. Why it is called intellectual property? Why it is a property? So why it is property? The trademark is a property, patent is property, or industrial design is property. We are having movable property like our land, our car, everything which can be moved, and we are having immovable property. This our building a house like this. Intellectual property different. Intellectual property means creation of individual's own intellect, like inventions, new design, new inventive trademark, any artistic work, any music composition, any literature, any book composition. So because this is individual's own creation by their own intelligence or intellect, so this is called intellectual. Why? Because property, because this is intangible. We cannot touch, and when this is intangible, when this is in our brain, we cannot touch or see. But once it comes out in our ideas, in our product, in our innovations, so it will become tangible. So it will become the property. So this is intellectual property. Trademark is one of the intellectual property. So IPR, intellectual property rights, protects patent, trademark, copyright, industrial design. As you can see, this IPR here in the slides, patents, copyrights, geographical indications, that is GI, industrial design. Now in this particular slides, there are some examples given. This you can refer the Coca-Cola bottle. This particular product is having different type of rights. One is related to the protection concerning its design. Okay, the shape of this container. So that is covered by industrial design. Other, the composition, although the Coca-Cola company has not asked for any patents, they remain with this formula for this manufacturing this drink a trade secret. Due to some limitations, the patents are having some limitations, and trademark is also having some limitations of time. This is limited protection. Patent is 20 years. So in order to keep it going on, they keep their secret as trade secret. So that is another aspect of this. And other is the Coca-Cola. So the name here, the Coca-Cola, is trademark. As its name signifies, the trademark, a mark or any shape, any logo which relate to individual's trade or business is a trademark. Geographical indications like this Kolhapuri chappal and Alfonso mango. This is called geographical indications because this is related to some particular geography like Basmati rice. That is India's geographical indications. Importance of trademark for business. So, as Mr. Malik has rightly pointed out, this trademark in the competitive business market, it's very crucial. Basically, because the trademark relates individual's business or it shows some connect with a particular manufacturer, business owner, or a trader, which due to its quality or other sort of things earn a goodwill in the public, purchasing public, or in the mind of the people buying the product. So they trust that brand, they trust that source, and they blindly or maybe with a good faith are ready to buy that product, which is maybe on the higher rate due to that trusted quality or maybe the services of that particular businessman or business organization. So trademark function as intangible assets for its owner. It allows customer to identify a business as the source of product or service and provides long-term protection for the brand. Why the protection of trademark is necessary? What is trademark? Maybe the Tata, Microsoft, Reliance, any brand name, any logo, any artistic work which is used in trade, maybe the trademark. So anything which is related to trade or which signify a particular owner or businessman or company is called trademark. For example, words, letters. A trademark may be a letters, a single letter, maybe in artistic manner, a combination of letter, a combination of words, any drawing, any picture, any shape is considered as trademark. Here is an example of well-known trademarks. You can see here this Yahoo, Adidas, BBC, CNN. These are the some well-known trademarks. It is not like that. It maybe a number of companies are operating with different brands. They generally, nowadays, they generally prefer to protect their brand name just to avoid the piracy, duplication, or just to avoid their competitors from encashing their own business. Because once maybe the brand is popular, it's people, the competitor and other people start copying. They are trying to trade, they sell their duplicate product or maybe the pirated product by putting the well-known company's trademark. So protecting individual business from piracy, from copying, from false competition, it is necessary to protect your intellectual property, that is your trademark. Let me share one example. I think in September last year, I was in Pulwama court arguing a matter before the district judge that was related to some trademark dispute between some Jamidar Keshar and Jamidar Keshar Mahal. So if you are going, I hope you must be aware of in the Pulwama area, Lithipura, there are number of shops with the same, there are number of Jamidar, Royal Jamidar, Jamidar King, Jamidar Keshar, New Jamidar, Best Jamidar, like this. So everybody is doing, but there are few traders which are having their goodwill. And one of them is Jamidar Keshar Mahal. I have represented Jamidar Keshar Mahal, and they are having their customers, including the CGI, Sachin Tendulkar, Suresh Raina, and most of the dignitaries are visiting their place. There are some other good traders also, good other shops also. But this is this particular trader is having their own goodwill, and they have earned their goodwill due to the quality of their products. And also other their business, maybe the rates and other services. Okay. So there were a dispute, and in which initially the injunction was maybe granted against our client, and we have filed the appeals for the same. The injunction was granted by a Munsarim court who is not having any authority. So let me share with you that this IPR aspect or the trademark and patent aspect, even the courts are not having good knowledge. Many of our colleagues, the new advocates, are not very much aware of this IPR laws, because somehow in the civil, criminal, and other sort of the areas, it is quite, I think, not attracting, or maybe the patents require science background. So in High Court, in Supreme Court, judges are not very trained about this trademark and patents. But now, specialized training is provided by patent and trademark offices in India to judicial members and other government authorities who are taking care of the like custom also. If we are importing some products from outside India, there is maybe trademark check and some certification and some authentication is also required in India by custom. So they are provided with some trainings regarding how to protect the piracy, copyright, duplicacy of the maybe imported product or Indian products. And judges are also provided with the same sort of training. And now in the High Court, we are having some judges who were well-known trademark advocates. They were elevated as a judge in the High Court just to deal, and the matter related to this IPR and trademark assigned to those benches only. So we got some order from Pulwama Court regarding the this, but in that order, I also, there were some things which were quite maybe clear, that even we argued the matter in length, but there were some aspects in the order which shows that the court is not having that sort of knowledge regarding the trademark protection, okay, or the rules related to trademark or trademark acts provisions. So this is important to protect your business, because you can see there is very small area, this sort of this fight is going on. Okay, duplicacy is going on. There are some websites launched by some competitor with this our client's name. Okay, so complaint was filed with the local police and economic offense wing. Then finally the matter was resolved. Okay, they were stopped from using that. So this is trademark, importance of trademarks. Protection is very necessary. If we would like to maybe run our business smoothly, then whenever nowadays the young people who are going in some, they are having some business idea, they would like to start business. First thing they would like to have in their mind, let me protect a trademark. First, book a domain name, protect a domain name, and also protect my name with the trademark registry. Or if I would like to register as a company, let me register or book a name with the the ROC, Register of Companies, so that other people will not start using the similar mark, and I will be protected, my business will be protected. Now, registration of trademark. The trademark is registered in India. We are having 5 jurisdictions, the 5 offices of government offices in India, where the registration is done. That includes Delhi, Mumbai, Ahmedabad, Kolkata, and Chennai. Trademark head offices based in Mumbai, but these 5 offices having different jurisdictions. Like our this Delhi jurisdiction include the Jammu and Kashmir, Himachal, Punjab, UP, and Haryana. So whenever there is any requirement of trademark registration by your clients, the jurisdiction lie with the Delhi Trademark Office. And what is the registration procedure of trademark? If a client is coming to protect your, or maybe to register a trademark, what is the procedure? What sort of information is required for that? So initially, trademark search is recommended. This is optional, but it is recommended just to check if my product is saffron, or my product is honey, or my product is any maybe wood item, that a search can be requested in that particular class to understand if there is any existing trademark is there or not. Is granted trademark is there, or a pending trademark is there? What sort of trademarks are there related to my mark or the brand which are going to register? If there is some mark, conflicting mark, then we generally advise not to proceed with the same and just to find out some other mark. Otherwise, use it without filing that with the trademark, because that would be exposed to competitors and they can initiate some trademark violation proceedings against you. So trademark search, once the search is clear, is positive, then filing is done. Filing is done. Now the online mode of filing is available. So you can file the trademark application from maybe from your location by registering yourself with the trademark registry. And once the trademark application is filed, it will be examined by the government office. Earlier, examination of trademark took lots of time, maybe number of years, 1 year, 2 year, or maybe it will take 8 or 10 years also. There were some examples where the trademark is granted even after the expiry of initial 10 years period. Now, it is very much expedited, and the trademark application after filing it may be examined most probably within a month time. And there is no objection or no conflicting mark. The registrar of trademark will issue the publication, will accept that trademark and publish that in the trademark journal. And after the publication of trademark in the journal, it will be open for 4 months from the publication date for the general public to file opposition, if any, or objections, if any. If there is no objection or opposition within 4 months of that publication, it will be registered and the registration certificate is issued. So after filing the trademark with the trademark concerned trademark registry, its status is available on the website. If I file your trademark or you file trademark today, it will be seen latest by tomorrow. But maybe the finance department or the online payment of department, trademark department will confirm that payment has been received by them. It will be available, and whatever documents we are filing as an attorney or advocate is available on the website. So it is not like that earlier we are having a different sort of document and we are having 10 documents from the client, we filed only 2, or there is any error from our advocate's end that he has provided power of authority, but we have not filed, and trademark is objected on the basis of the incomplete filing or informalities. What are the requirements for the trademark filing? What sort of information you may require from your clients? That is basically the trademark. That may be your logo, and the list of products. So just to maybe confirm the class, initially, this is required for trademark search. Once the search is okay, then for filing the trademark, you may ask your clients to provide for their name. If the trademark is registered in the individual name, the individual's name in the format last name, first name, and nature of the applicant, whether this sole proprietorship and the partnership or the company. And nowadays, for some time, the trademark office mandates the filing user affidavit. A trademark can be filed as proposed to be used. If you are not using, suppose if there is some idea or some name in your client's mind and he would like to protect that, he can approach to you can file the trademark even he is not using. There is a requirement that once the trademark is filed, it must be used within 5 years of the filing. It is not like that if you blocked some trademark and you are not using that indefinitely. So there is a time period of 5 years. A trademark can be filed as proposed to be used. But if a trader or a company using a trademark, then they need to submit the user affidavit. These are user affidavit concerning the use of that, and they can also submit along with the user affidavit some evidence. The evidence may be their invoices, their will, their publication of their mark in exhibitions, any evidence which prove that the trademark is in use at the time of filing. So there is a user date in the affidavit. So user affidavit is also required, and the other is power of authority. That is nothing. The power of authority is nothing but an authorization of advocate or trademark agent. This is maybe provided on the form 48. So there are a specific format for this form TM 48, that is the power of authority. Then what is the fee? Trademark application fee is 10,000 rupees for legal entity or corporates. And 50% discount is available for individuals, that is the proprietors or natural person. But the government this government is also providing 50% waiver on this fee to MSME, the company who are registered in the MSME, registered in Laghu Udyog or MSME. So 50% reduction. Further, 10% discount is also provided on online filing. So 10,000 fee become the 9,000 and 50% of that is 4,500. So this is the fee for one mark in one class. And there are 45 classes in trademark, 1 to 45. 1 to 32 relate to product classes, which deals with the products category. Like for the saffron and the some other eating edible product, there are 29, class number 29, 30. And class 34 to 45 are related to service classes. Suppose I'm a doctor. I don't provide any medicines, or I'm not having any chemist, but this would be my service. So my services are covered, or being a lawyer, my services are covered under the service class. If I'm trading, I'm marketing or selling some products, so that that product is covered under the product class. So registration is class specific, and a single application can be filed for multiple classes, class 1 to 45 in all classes, if required, or separate application individually filed for each class. Fee applicable is class based. Even if you are filing a multi-class application that is in class 99, you are covering 4 classes. You need to cover, or you need to pay multiple of that individual class, that is 9,000 into 5 or 4. So it saves only advocates time, but sometimes it is quite complex, because your trademark is objected in one class, then that will be having adverse effect on other class also. So once the trademark is filed, it is examined. If examiner examine the trademark application, and examiner simply check whether this is not a well-known trademark. What is the well-known trademark? The well-known trademark has nothing but the trademark like this any which we know, okay, Yahoo, Adidas, BBC, Coca-Cola, Google, IBM, these are well-known trademarks. So even if IBM is related to electronics, computing, or this communication, a person who is maybe trading with the jewelry cannot use this brand name IBM because this is well-known trademark. So generally the registration is because well-known trademark is category which is created just to protect these sort of well-known national or international brand. Earlier what was happening? The people are starting using this maybe any well-known brand for their, if they are trading the lipstick, they are using this Puma lipstick, Pepsi. So because they are having a recognition or maybe the image in the public, they would like to, okay, the Pepsi company or maybe the other company started with this sort of products also. So it restrict, well-known trademark restrict any person or anyone from using that trademark in any category. Now, if trademark is ordinary trademark, then the registration is specific to class, 1 to 45 classes. If I am an advocate and I would like to protect, if suppose we would like to court cast as a trademark, so we can file this trademark in the service class related to the legal profession or maybe the lectures. A court cast can be used by a trader who is trading some products, maybe the jewelry, maybe salt, or maybe eatable, or maybe medicines. So this is the class specific. We cannot claim, okay, that this is our trademark. We are doctor, we are engineer, we are lawyers, and we will restrict other person, a jeweler or maybe a trader or a pharmacist from using this trademark in their business. So this is registration is class specific. The trademark registration is jurisdiction specific. If we registered our mark in India, now, okay, one more thing. Although we are having 5 jurisdictions in India, but if we registered trademark with Delhi jurisdiction, which covers Jammu and Kashmir also, the registration will be valid throughout India. Whole India, the registration will be valid. So it is not like that I am registered my trademark with the Delhi office and I'm practicing or trading in Kashmir, and someone else start using my trademark in maybe north, east, or maybe south. They will not be allowed to use your mark or the registered mark. If in this case, we can file a case for infringement or passing off can be filed. So this is jurisdiction simply cover the different states and their work. Other trademark is well in India, and this is in India only. In US, there is single office that is in Alexandria, Virginia, and the trademark is maybe registered, examined and registered therein. If there is a that is a quite detailed thing. There are some mechanism and means to register a trademark outside India. So there are some treaties and some instrument that by filing the international application, we can seek registration of trademark in designated countries, say Europe. If my client trade is related to Europe, maybe Gulf countries or US, Canada, I can file a international trademark with WIPO, and that by designating the respective countries, and my mark will be examined and registered by individual countries. So if I registered a trademark in India, I cannot claim the protection outside India because these are the territorial rights, but protection is also territorial. Initially, trademark is registered for 10 years and it may be protected for many years. You simply need to get it renewed every 10 years. It may be renewed after the renewal window is open after 9.5 years, and it can be registered during that window, 9.5 years to 10 years. And thereafter, the trademark is lapsed if you not renewed that within time, and the trademark can be restored. So this is related to trademark. Now let me also discuss. I think our topic is trademark and its importance for business. So I think that trademark, when its importance on business, whatever I have discussed, maybe clearing some aspect of it. If there is any question regarding this, I can discuss right now, or otherwise I would like to also invite your attention on the some other aspect of intellectual property briefly.
Sir,
That
I
is-
think we will take questions at the end.
Okay, so let me briefly also visit on the other aspect of intellectual property rights, because sometimes there are lots of innovations and other work is also going everywhere, including the Jammu and Kashmir. So we are having some work related to patents and industrial design, more specifically industrial design. So let me discuss about the patents. The other aspect of intellectual property is patents. Patents are nothing but a certificate or a monopoly which is provided to its inventor for its creation. Suppose I have invented some invention. If I have invented some formula for curing this COVID disease or some cancer treatment, then I am entitled for that to get patent, and I am entitled for exploring or having the commercial aspect for my patent or my invention. The protection period is 20 years. What can be patented? Anything which is new, non-obvious, or inventive. That means new means which is not known to maybe persons of that field, and that is having some utility. Suppose if someone, there is a Kashmiri kahwa, and if someone has created maybe different thing in that kahwa that can cure maybe the cold or maybe some other sort of things, maybe fever, and that is not disclosed or claimed by anyone, then he is having he is entitled to have a patent for that. But the innovations of involve some inventive aspect. Okay, inventive aspect means the feature of your innovation. आपने चाय बनाई, चाय में आपने 3 चीजें. I think Hindi is comfortable to all of you.
Yes, sir. Yes, sir.
Okay.
Very
So
good.
if we prepare a tea, चाय तो सारे लोग मिलाते हैं, बनाते हैं, दूध है, चाय पत्ती है, शुगर है, पानी को बॉईल करते हैं. लेकिन if there is something and any other element किसी ने बनाया या इसको पर्टिकुलर एक मेथड से बनाया, कोई उसने इंग्रेडिएंट इसमें ऐसा मिला दिया जिससे इसकी जो चाय की जो बेनिफिट्स हैं वो किसी पर्टिकुलर चीज को क्योर करता है, बट वो इंग्रेडिएंट इसके इन्वेंटर ने अपनी रिसर्च से इनोवेट करके उसमें बनाया और ये खोज की, देन इसको पेटेंट इस चीज के लिए मिल जाएगा. बट सिंपली 2-3 चीजें मार्केट में अवेलेबल है, 4 अवेलेबल हैं. By mixing a mere combination of available things, the A, B, C, and D are available in the market, and differently, not in combined word. Or I have created something by combining those things, so I am not entitled for a patent. So patents are granted for any innovations. किसी ने सॉफ्टवेयर प्रोग्राम बना दिया, I get there are lots of patents for this computer, mobile phone cameras. Earlier, initially, there were camera few megabytes of megapixels. Then 2 megapixel, 10 mega, now 40 megapixels. So there are patents for everything. There are patents for this MS Word and this PowerPoint. These are the softwares. They are also patented by the way of patent protection. Now, this industrial design is also important aspect for your region, because there are lots of creation, wood crafting, wood designing. So anything For a carpenter is creating some, maybe manufactured a chair or a stool or anything which is new, which is having new design, then he would like to protect that. He can be protect his designs. Any article who is having some different ornamental features or the shape or design can be protected by the way of design. So this is called design patent. So IPR is having patents, trademark, industrial design, and copyright. For example, in this slides, you can see the seizure, this chappal, this bottle. Initially, we were having that Coca-Cola bottle design, this comb, this brush. So any new shape can be protected by the way of industrial design. Even the packaging of this pharmaceutical products, medicines, they are also protected by the way of industrial design. It is valid for initially for 10 years. Sorry. But copyright also exists in the industrial design. So 4-year copyright protection also available. So total protection is 14 years. The jewelry, lots of patents, design patents are filed for jewelry design. And also carpet. The carpet is very popular in maybe the design of any shawl, like, or any curtain, that can be protected by the way of industrial design and also by the way of copyright. The geographical indications I have discussed, this is related to the particular geography. So anything that basmati rice, Alfonso mango, Kolhapuri chappal, they are maybe manufactured or created in that. So this is the GI protection for those. Darjeeling tea, Nagpur orange, Bikaneri bhujia, Agra peta, all these are the geography. So this will give you an idea of what is the geographical indications, what is a trademark, what is industrial design, and what is patent. Generally, many of the time it is said that okay, this is मेरा patent है इस पर, ये किताब तो मेरी patent है. किताब तो patent नहीं होता. किताब, बुक जो भी है या कोई भी लिटरेचर है या इस तरह का वर्क है, that is protected by the way of copyright. So copyright, the other aspect that is also very important aspect of IPR, that is copyright. Copyright covers any literary means in the form of literature, any work, any novel, any book that is protected by the way of copyright. Any artistic work, any painting, any cinematographic work, okay, any picture, movie, any song, any music composition, any software program that is protected by the way of copyright. Advantage of copyright, even a trademark can be protected by the way of copyright. If I am having maybe any design or logo which is used in trade, is protected by the way of trademark primarily, but it can also be protected by that design by the way of copyright, because there is some artistic creation of that design. So that artistic work is created by the way of copyright. Advantage of registering trademark as well as protecting that by the way of copyright is this. For trademark, an owner need to require it renewed every 10 years. But for copyright is applicable throughout the life of the owner, and even after many years for the subsequent, after demise of that owner. So, and it protect itself in the more than 100 countries, which are because India is also signatory to the Berne Convention, which mandates protection of copyright to its member states. So more than, I think, 30 countries or 35 countries are member to Berne Convention. So by registering copyright in India, this can be protected throughout the world. Now this your invitation card is also having a copyright protection. Why? Because there is some different design creation. So the design of this card is protected by the way of copyright. That is the artistic work. And if you would like to protect this by the way of literary work, then whatever the literature is there, so that can be protected by the way of literary work. Now let me share with you, different rights can be may exist in a single article. Let's see this in this slide, this Coca-Cola bottle. You can see, as I discussed, the shape of this bottle is protected by the way of industrial design. Any composition of this drink or liquid, which is unique and which is inventive, that is protected by the way of patent. However, as I discussed, its owner decide to not file or protect their trade secret by the way of patent, and it remains still the trade secret. And the brand name Coca-Cola is a trademark. So in this particular product, we can see there are 4 rights. Industrial design is also, trademark is also, patent is also, and trade secret, copyright also. This label logo is also registered by the way of copyright. Now, this image of this apple is protected by the way of trademark, and the ornamental configuration of this phone, what is the shape, how the keyboard are arranged on its panel, okay, where the camera port is there. So this sort of ornamental configuration, the shape is protected by the way of design. The packaging or the box in which it is packed, and that box is protected by the way of the shape of that box is protected by the way of design. And the whatever the literature is there, artistic work is there on this packaging, that is protected by the way of copyright. Let me give the other example of this. We are having any medicine, this Calpol or paracetamol. This paracetamol is a brand name, or this is a trademark. The packaging of strips, a different shape of that can be protected by the way of design. In the matter of the prescription of other details are maybe printed on that, that is protected by the way of copyright. So different IPR can subsist in a single product based on their nature. Now we have discussed that so far we have discussed patents, trademark, copyright, industrial design, and trade secrets. Here is it in this slide, you can see that maybe there are different offices. The patent and design office is based in Kolkata, Delhi, Mumbai, Chennai. So Ahmedabad, this patent office is not there. Trademark office is located with these 4 plus Ahmedabad. Geographical indications office is in Chennai. So now let's briefly discuss about the international organizations. So the World Intellectual Property Organization and World Trade Organization. World Trade Organization deals regarding the trade related to different products, but IPR aspect of this international organization is dealt by the World Intellectual Property Organization. This is based in Geneva, Switzerland. So this WIPO, generally it is referred as WIPO, World Intellectual Property Organization. This facilitates or provides or work as and maybe the bridge between the owner and the protecting authority. So earlier, if I need to, my client need to register their trademark in 10 countries, they need to file, they need to hire advocates in 10 countries. They need to they pay the fee in 10 countries, and lots of inconvenience were there. So WIPO provides some mechanism to file a single application, that is the trademark application, that is called international application, and to designate number of countries of your choice or of your requirements. So WIPO is the body which deals the international registration and process related to trademark registration. Validity of intellectual property right protections, patents 20 years, no rights after expiry of patent. So generally, when there are drugs which are in public domain, that is called generic drugs. Generic drugs are nothing but the drugs which are manufactured by different traders or manufacturer after their expiry of its patent protection. Trademark is lifelong, but every 10 years we need to get it registered. Design is 15 years, 10 years initially, and after 5 years additionally. Copyright 16 years, 60 years, no renewal is required. And geographical indication GI is also for lifetime. So I think this is what I was for this presentation. Now we can discuss the questions, we can take the questions or any doubts or anything which I need to clarify regarding this presentation.
So now,
Mr. Malik.
yes, sir. Sir, now we will open the floor for questions. Anyone among the audience who wants to ask a question would kindly raise their hand. And once that has been reflected on our displays, we'll allow questions one by one. So I request anyone having any doubt or wanting any clarification to kindly raise their hands. So till that time, sir, I would start with the questions. So my first question would be, in terms of trademark laws, what is the importance of being a prior user? Even if somebody has registered a trademark and the prior user has not, does he get any priority to use that trademark by virtue of being a prior user in the market?
Mr. Malik, very good question, and I think I left this aspect. Basic necessity of this trademark registration is prior user. Whosoever start using the trademark in first is having proprietary right over that trademark. If he is continue in that business, he is using that trademark continuously without any obstruction for maybe more than 5 years. Okay. Even without registering a trademark, he can stop from the others who may have fraudulently or intentionally registered that trademark with the government of India. Okay. Many of the times, once the trademark is filed, the examiner conduct the trademark searches in relevant classes. So by the keyword searches, if there are few letters, few words, they search and they came across number of related trademark and they cite those trademark in the examination report and they object that. The applicant can file their reply, trademark is accepted. But if there is a trademark who is used by someone else prior to the filing of this trademark, or maybe the user date by the subsequent that person, and whose record is not available with the registry. So registry is not faulty in this regard because the registry check their own record. But now, in this case, a prior user can approach to the court for injunction, for a stay against the misuse of their trademark by someone else, the second party or third party. He need to provide the information to prior user claim or the prior user the priority which must be given in all aspects. This is the one thing. I am a prior user. Then you start business after some times. And I am not restricting you to use your trademark. Then I am losing my right of limitation. If I am aware of that someone else is using my trademark, although I have not filed that with the government of India or registry, then I can send a legal notice to them. Okay, this is my mark. This is I am using for this period of time, and you cannot use the same for the same product. I can restrict if you're not stopping, you're not maybe complying with my record, I can proceed to the court. So that's why two types of cases are filed.
All right,
One is
sir.
the passing of the trademark, and other is the infringement. There is a
Infringement.
difference between the passing of trademark and infringement of trademark. Basic difference is this: if your trademark is registered, then you can initiate a action of infringement against the registered trademark. So action of infringement is initiated against a registered trademark. And if the trademark is not registered, but it is used in and well known, then the owner of that trademark initiate action of passing off. That someone else is passing off my goods. He is using my name. So
All right, sir. Okay, sir. Sir, you can continue, sir.
So this is the basic difference. The prior user is the having always priority over others.
All
There is some example you can see that some Rajnigandha sort of the masala was there. Okay.
all right. Yes, sir.
And there was some owner of that, I understand that is in the Kashmir based, the original, the Rajnigandha. And he stopped that big company from using their mark. He claimed and he proved that I am the prior user. This is my brand. Then Rajnigandha later on, I think, become the RMB sort of things that, but
All
not.
right. All right, sir. Sir, the next question would be from a person who has written his name as Dr. Bilal. Dr. Bilal, please ask your question. So I think we have lost connection with him. Next is Mr. Salfi Izhar. He will ask a question now, which will be followed, of course,
Hello.
by
Selfie
Fiza
is a-
Nawal.
Hi, sir.
Yes,
Thanks
yes.
for joining all the way from Delhi. And sir, actually, I have a question. So, does civil courts have jurisdiction on the issue if someone is filed application before that's pending before the registering authority? So, can they grant interim injunction for any aggrieved client who is filing case before the concerned court?
Yes, Selfie is our. Thank you so much. And let me share with you, Mr. Selfie Jar was with me in Pulwama Court. I think when we were arguing that matter. He is very interested in IP and trademark matters, and his research and work is also very good. So thank you very much, Mr. Ijar. This proceedings before the trademark registry doesn't restrict this district court to exercise its jurisdiction. Okay. So there are a number of cases in what was there in that particular cases which I have maybe referred earlier. There's Jamidar Kesar Mahal and Jamidar Kesar. The proceedings are going on in the Delhi Trademark Office. What happened in this case? Jamidar Kesar is registered by a owner. Jamidar Kesar Mahal is registered by different owner. Both are examined and registered by the trademark registry. Jamidar Kesar tried to restrict Jamidar Kesar Mahal. They initially sent some legal notice and they filed some maybe the suit for the injunction to against the use of their trademark by claiming this is infringing their trademark. Despite there were some matters which were going on, Jamidar Kesar Mahal has filed the rectification or removal proceedings before the trademark registry in Delhi against the registered trademark of their competitor. In the counter blast, the competitor also filed the case for rectification or removal of this Jamidar Kesar Mahal. So although these proceedings were going on with the trademark registry, but the jurisdiction of this Pulwama court was different and broad because they were examining key, is there any infringement, whether they are having exclusive rights, whether they are having any prior user. The matter that initially, the Mr. Malik, the prior user were the aspect which were greatly
Yes, sir.
considered by the court. In that, we were able to establish that we are the prior user, and with regard to the prior user, we have submitted some evidence regarding the bank account details, operating this much of time, government records, okay, and other evidences, which are not like my bills or other sort. These were the evidence, but there was some evidence which are available on net, or the bank record, the transaction, my company name is there with the name. So these were the evidence which established, okay, yes, the Export Import Council, the Food Processing Council, the Tourism Department, the GST registration. So which established, okay, this is the prior user of this mark. And so that's why the injunction is refused. So they, Mr. Izar, the trademark registry proceedings like rectification, opposition proceedings doesn't restrict the district court to exercise its jurisdiction.
All right, sir. Thanks a lot. Now, again, Mr. Dr. Bilal, may I ask the question? I think we have, we have connected to him. Please ask the question.
Thank you for nice presentation, sir. Sir, I have a couple of questions. My first question is, what type of correlation exists between IPR in general with competition and trademark in specific? Because if we look at the data at world level, the data is from World Intellectual Property Indicator 2019. What do we observe there? There are 5 countries in the world who have filed 65% of trademarks. That means जो लो इनकम इकोनॉमीज वर्ल्ड के हैं वो बहुत कम ट्रेड मार्क फाइल कर पाते हैं. एक तो मेरा ये क्वेश्चन है कि जो गरीब ममालिक हैं उन पे क्या इम्पैक्ट पड़ता है इस ट्रेडमार्क का. दूसरा मेरा ये क्वेश्चन है कि ट्रेडमार्क जो है क्योंकि ये मोनोपोलीज को जन्म देता है, मोनोपोलीज को जब ये जन्म देता है तो अल्टीमेट कंज्यूमर पे क्या इम्पैक्ट पड़ता है. और मेरा तीसरा जो क्वेश्चन है वो ये है कि एज इफ वी लुक एट द इंडियन इकोनॉमी 400 फैमिली जो हैं उनके पास 80% जीडीपी शेयर हैं. ये ट्रेडमार्क जो है ये इनइक्वालिटीज को और इंक्रीज नहीं करता है. तो इन सब चीजों को हम कैसे, यानी गवर्नमेंट को कौन से ऐसे स्टेप्स उठाने चाहिए जिससे इन चीजों को कंट्रोल किया जा सकता है. थैंक यू.
थैंक यू डॉक्टर बिलाल. आपके 3 क्वेश्चंस हैं कि मेनली जो ट्रेडमार्क है उस पर मोनोपोली उधर मेजरली 5 कंट्रीज हैं, उनका ज्यादातर है 50+%. गरीब पे क्या इफेक्ट पड़ता है और जो मोनोपोली की वजह से जो पूरा कंट्रोल है उसमें भी वो दोनों एक ही हैं कि गरीब पे एक तो ये है कि गरीब के ट्रेडमार्क पे क्या फर्क पड़ता है, दूसरा इस मोनोपोली होने से गरीब की परचेजिंग कोई है उस पर क्या फर्क पड़ता है. यही क्वेश्चन है आपका?
यस सर, यस सर.
ओके, देखिए ये बात ठीक है कुछ हद तक कि ट्रेडमार्क को जो है ना एक प्रकार से मोनोपोली है, या जो गरीब जो डेवलप कंट्री है वहां आईपीआर प्रोटेक्शन बहुत इफेक्टिव है और डेवलपिंग कंट्री और लीस्ट डेवलपिंग कंट्रीज में इफेक्टिव नहीं है. मैंने ये डिस्कस किया कि गवर्नमेंट फीस की 10,000 है इंडिया में फॉर एग्जांपल, और गवर्नमेंट ने 50% डिस्काउंट दे रखा है. किसको? मीडियम स्मॉल एंटरप्राइजेस और लघु उद्योग को. इंडिविजुअल इन्वेंटर लाइक आपके कोई भी है उसको 50% डिस्काउंट है, यानी 10,000 वाली फी वो 4,500 चार्ज की जा रही है. इसके अलावा गवर्नमेंट ने कुछ फैसिलिटेटर भी एक लिस्ट पर हैं जो फैसिलिटेट करने के लिए इंडिविजुअल जो गरीब हैं या पैसे खर्च नहीं कर सकते हैं, तो एक लिस्ट है फैसिलिटेटर्स की, मैं भी उसमें रहा हूं, कि उसके लिए आप जाइए एडवोकेट्स को अप्रोच करिए अपनी पसंद के, और जो एडवोकेट की फी है वो गवर्नमेंट देती है एडवोकेट को. हालांकि ये बड़ा कॉम्प्लेक्स है तो बहुत लोगों को इसका फायदा जानते, गवर्नमेंट की पॉलिसी उतनी आसान होती नहीं है तो उसका नहीं मिलता है. तो गरीब जो ट्रेडमार्क लोग लेके और जिसका जो ट्रेडमार्क है और वो नो प्रोटेक्ट नहीं कर पाया, तो एक ही फैक्ट है कि उसको पैसे की वजह से प्रोटेक्ट नहीं कर पा रहा. बट मुझे लगता है कि ये 4,500 रुपए की गवर्नमेंट फी और जो प्रोफेशनल फी वो भी रीजनेबली होगी, वो एडवोकेट्स की इंडिविजुअल डिपेंड करती है. इतनी ज्यादा है कि जो इंडिविजुअल इस ट्रेडमार्क को आगे ट्रेडमार्क लेना चाहता है ही मस्ट बी हैविंग सम गुड, वेरी गुड, मतलब बिजनेस एस्पेक्ट और आइडियाज कि उसको ग्रो करना है, कहाँ जाना है। तो इनिशियली आपको जरूरी नहीं है कि आप ट्रेडमार्क के लिए आए। जैसे मैंने कहा कि ट्रेडमार्क रजिस्ट्रेशन इज नॉट मैंडेटरी। Even without registering your trademark, you can restrict others from using or infringing your this trademark or passing off your trademark. तो ये एस्पेक्ट रहा। दूसरा, मोनोपोली दूसरे लोगों की, बिकॉज डेवलप्ड कंट्री में आईपीआर का एस्पेक्ट बहुत पहले से रहा है। हमारे यहाँ बहुत सारे हमारे जो साइंटिस्ट थे या वैसे लोग थे, उन्होंने बहुत सारे पेपर सुब्रमण्यम और उन्होंने पब्लिश किए, और उनके पेपर पब्लिकेशन से लोगों ने यूएस में और वहां पेटेंट्स ले लिए। अब देखिए, हल्दी को यूएस ने पेटेंट कराया, तो ट्रिप्स में हम लोग WTO में गए तो उसको हमने कैंसिल कराया। कितनी सारी इनकी आयुर्वेदिक इंडिया की रिसर्च ने बाहर कराया उन्होंने। तो डेवलप्ड कंट्रीज ने उसको बहुत वो एक्सप्लॉइट किया है, जो इंडियन ट्रेडिशनल नॉलेज है या जो चीजें हैं उनमें उन्होंने पेटेंट लिए हैं। और वो पेटेंट लेने की वजह से, या ट्रेडमार्क का इतना नहीं है, महंगाई पर पेटेंट्स का ज्यादा है। आपको मैं बताऊं, जो महंगाई है जो गरीब को परेशान करती है, वो पेटेंट्स राइट्स करते हैं। अब अभी जो G20 और उससे पहले जो मीटिंगें हुई थी या कोविड के बाद, एक इशू सबने रेस किया था कि जो फार्मास्यूटिकल कंपनी मॉडर्ना है, फाइजर है या जो भी हैं, ये अपने कोविड की जो उन्होंने वैक्सीन डेवलप की है, आईपीआर वेवर दें, इंटेलेक्चुअल प्रॉपर्टी राइट वेवर, सो दैट द अदर कंट्रीज लाइक इंडिया या दूसरे जो है वो मैन्युफैक्चर कर सके इनके फॉर्मूले के बेसिस पे। उन्होंने नहीं दिए। तो जो चीज जेनरिक ड्रग आपको 1 रुपए की मिलेगी, वो पेटेंटेड ड्रग वो 30 रुपए की मिलेगी। अब डायबिटीज की एक टैबलेट है, मैं यूज करता हूं उसको, आप उसको एवेंटिस या दूसरी कंपनी की ले लीजिए, वो 30 रुपीज की एक टैबलेट आती है। सेम कंपोजिशन जो जेनरिक ड्रग है वो आपको 3 रुपए 4 रुपए का मिल जाता है। तो ये कॉस्ट को तो करते हैं और गरीब सफर होता है, लेकिन गरीब सफर ट्रेडमार्क में नहीं होता। आज का प्राइमरी टॉपिक हमारा एस्पेक्ट ट्रेडमार्क को लेकर है, और ट्रेडमार्क पेटेंट्स दो डिफरेंट चीजें हैं। ट्रेडमार्क के लिए कोई भी गरीब मतलब 10-1,000 रुपए खर्च करके आप ट्रेडमार्क ले सकते हैं। और ये जरूरी नहीं है कि आपने बिजनेस शुरू की तो इनिशियली जाइए, आप बिजनेस में आप प्रोग्रेस करिए, जब आपको लगे आपकी बिजनेस चलने लगी है तो आप ट्रेडमार्क प्रोटेक्शन खाइए, क्योंकि अदरवाइज आपका बिजनेस खुद का ही नहीं चल रहा, ट्रेडमार्क आपका कोई दूसरा कॉपी नहीं करेगा। ट्रेडमार्क की कॉपी या पायरेसी तब होती है जब आपका बहुत वेल नोन ट्रेडमार्क हो जाता है। अभी रेवान के गॉगल से या जो चीजें आ रही है इनकी देखिए कितनी पायरेसी हो रही है। किसी अच्छी कंपनी का पर्स आ गया, उनको डुप्लीकेट दिल्ली में बहुत मार्केट में हर जगह मिलते हैं। ये रहा। तीसरी चीज, गरीब इससे इफेक्ट होता है। तो मुझे डॉक्टर बिलाल लगता है कि गरीब जो इफेक्ट हो रहा है, या गरीब जो कंट्री है, जो डेवलपिंग कंट्री है, लीस्ट डेवलप कंट्री है, वो बहुत इफेक्ट होती है कि जब उनको किसी चीज की जरूरत है, दवा की जरूरत है या किसी दूसरे डिवाइस की जरूरत है, और वो सिर्फ इसलिए बहुत महंगा है क्योंकि उस पर पेटेंट्स राइट्स एडजस्ट करते हैं 20 ईयर्स के लिए। उस पर काम करना चाहिए, लेकिन ये मोनोपोली है डेवलप्ड कंट्रीज की जो अभी जारी है। और डिस्पाइट बहुत सारी लॉबिंग के बाद भी किसी कंपनी ने अपने वो राइट्स, या रिसेंटली जो इसको कोविड के बाद में उन्होंने नहीं डाइल्यूट किए थे कि आप इसको मैन्युफैक्चर करिए और इसको सस्ते में उसमें दीजिए।
थैंक यू सर। एक्चुअली ये मतलब मैंने ये क्वेश्चन किया था इन जनरल ऑफ आईपीआर। तो थैंक यू फॉर
हाँ, इसीलिए आई हैव आल्सो कवर्ड ना दिस पेटेंट एस्पेक्ट, बिकॉज मिस्टर मलिक ने मुझे बोला था कि इसमें ट्रेडमार्क के लिए है, बट ब्रीफली अदर एस्पेक्ट ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट वी कैन कवर, सो दैट इज गुड।
दैट इज व्हाई मेरा क्वेश्चन एक ये था कि जो हमारा आईपीआर इन जनरल है और ट्रेडमार्क इन स्पेसिफिक, इसमें हम एक चीज देखते हैं कि मोनोपोलीज क्रिएट हो जाती है, और जो पोटेंशियल प्रोड्यूसर्स होते हैं, पोटेंशियल प्रोड्यूसर्स जो वही चीज उससे बड़ी क्वालिटी का दे सकते हैं एट लोअर प्राइस, दैट विल बी अवेलेबल फॉर द कस्टमर। बट जो एक मोनोपोली ऑलरेडी उन्होंने अटेन की है, उससे पहले जो पर्सन है, वो चीज सस्ती दामों तक लोगों तक नहीं पहुंच पाती है, वो एक क्योंकि सप्लाई शॉर्टेज हो जाती है। और एक ऐसी चीज जो मतलब इफ वी टेक द केस ऑफ इंडियन इकोनॉमी, यहाँ पर ऑलरेडी बहुत ज्यादा इनइक्वालिटीज हैं, और यहाँ से जब ये इनइक्वालिटीज हैं तो ये ट्रेडमार्क जो है, ये क्या आपको नहीं लग रहा है कि खाली अमीर लोगों को ही फायदा पहुंचा रहा है? और एक और चीज जो मैं ऑब्जर्व कर रहा हूँ, एंड आई हैव एविडेंस विथ मी, दैट इज डेटा। और एक और चीज जो मैंने ऑब्जर्व किया डेटा को पढ़ते हुए, वो ये मैंने देखा कि जो हमारे जीडीपी जो है, अगर पोटेंशियल प्रोड्यूसर्स को एलो किया जाए तो हमारा जीडीपी जो है वो अगर इसका 8% कंट्रीब्यूशन है वो 8 से तकरीबन 12% जा सकता है आईपीआर का। तो दीज आर माय क्वेश्चंस। थैंक यू सर।
डॉक्टर बिलाल, आपके क्वेश्चन इकोनॉमी और उन सारी चीजों से रिलेटेड कुछ है, एस्पेक्ट कंसर्न भी हैं, एंड आई अप्रिशिएट दैट। और जैसा मेरा ये मानना है कि ट्रेडमार्क रजिस्ट्रेशन लेना या इसको प्रोटेक्ट करना किसी गरीब के अधिकार को अब किसी ने देखी। बेसिकली अगर आप एक ट्रेडर हैं या आपके पास कोई प्रोडक्ट है, आपका अपना ट्रेडमार्क है, आप क्यों ट्रेडमार्क कराना चाहेंगे? बिकॉज एक तो आपका दूसरा कॉपी नहीं करे, और दूसरा आपके मार्केट में एक्सेप्टेबिलिटी गुडविल तभी होगी जब आपके प्रोडक्ट अच्छे होंगे या पब्लिक की नजर में उनकी एक इमेज होगी, है ना। तो जब वंस यू क्रिएट दैट इमेज इन परचेजिंग पब्लिक, और जो लोग हैं आपके बायर, तो वो आपके ट्रेडमार्क को आपके साथ सिग्निफाई करेंगे और रिलेट करेंगे। अब उसकी कोई डुप्लीकेशन नहीं हो तो उसके लिए आप ट्रेडमार्क प्रोटेक्शन लेंगे या दूसरे मीन्स लेंगे। अब जब आप ये सारी चीजें ले लेंगे तो ऐसा इसमें ट्रेडमार्क में मोनोपोली नहीं है। आप कोई भी एग्जांपल दीजिए किसी बड़ी कंपनी का, आप जैसे रिलायंस है, वो अपने प्रोडक्ट्स हैं, फिलिप्स है, उसके अपने प्रोडक्ट्स हैं, उनके कंपटीशन में इतने सारे हैं, पैनासोनिक के और कितने सारे हैं, तो वो उनको अपने 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 को डिस्टिंग अपने बताना कि दिस इज सोर्स ऑफ माय प्रोडक्ट। फिलिप्स इंडिकेट ए पर्टिकुलर डिफरेंट सोर्स, एप्पल रिप्रेजेंट ए डिफरेंट, रियलमी चाइनीज कंपनी, दीज आर डिफरेंट, सो दीज आर द ट्रेड नेम। इनका गरीबी से लेके और रेट बढ़ने से लेके इनका ट्रेडमार्क पे मुझे इनका नहीं लगता। लेकिन हाँ, जो ब्रांड है, आपने शूज ले लिए, नाइकी के शूज का आप देखिए क्या है, प्यूमा के, स्केचर्स के, तो उनके ब्रांड नेम तो वो अपना, क्योंकि जब आपकी प्रैक्टिस होती है, आपका कंट्रीब्यूशन होता है, तो आप वही तो इनकेस करते हो ना अपने ब्रांड नेम पे, तो उसका एडवांटेज आपको मिलता ही मिलता है। इकोनॉमी, आई एम नॉट वेरी एक्सपर्ट ऑन इकोनॉमी, तो मैं इकोनॉमी के बारे में ज्यादा कुछ नहीं कह पाऊंगा।
थैंक यू
It's
सर।
all
थैंक
right,
यू।
sir. So
Thank you,
we'll
sir.
take
Sir,
the next
my-
question from Mr. Tawfiq Khaja. Mr. Tawfiq Khaja, please ask your question. So, sir, I think we have lost connection with Mr. Tawfiq Khaja. Mr. Pirzada Bari had also raised his hand at one point of time. Mr. Bari, if you want to ask a question, we'll give you an opportunity.
Yeah, Mr. Fahad, thank you very much for allowing this opportunity. And simultaneously, I would like to congratulate our learned guest, Mr. Vijay, who is a very great legal luminary, seems a very specialist on the subject. आज देखिए सर, मैं आपकी अनुमति चाहता हूँ। जैसे आपने ड्यूरिंग योर लेक्चर आपने कहा था कि क्या आप हिंदी से के साथ सहमत हैं, कंफर्टेबल हैं, तो ठीक है। छोटे बच्चे हैं इस ग्रुप में, मैं जानता हूँ इस ग्रुप की जो वसअत है दिन ब दिन बढ़ रही है फहद साहब की काविशों की वजह से, और जो बाकी इस टीम के साथ एसोसिएटेड हैं, जैसे ये बुखारी मैडम है। तो खैर मुझे ज़्यादा नहीं, ये टॉपिक, ये जो इंटेलेक्चुअल प्रॉपर्टी राइट्स आईपीआर का टॉपिक है, बहुत वास्ट है, लंबा है, इसका स्कोप भी बढ़िया है। लेकिन मेरे कुछ कॉमन सेंस क्वेश्चंस हैं जो आज तक जैसे भी मैंने जहाँ जितने भी केसेस, चाहे मैंने छोटे मोटे डील किए ट्रेडमार्क को लेकर, यहाँ पर तो काफ़ी उतना इंडस्ट्रियलाइजेशन है नहीं, लेकिन खैर आपकी वजह से काफ़ी यहाँ पर ये एक इंस्पिरेशन मिल रही है कि इट्स सॉर्ट ऑफ हमें फ्यूचर में आपकी लेक्चर की वजह से काफ़ी झांकने की हमें वो इंस्पिरेशन मिली है कि क्या हो सकता है फ्यूचर में। खैर सर, आपने पासिंग ऑफ का जिक्र किया था सर। पासिंग ऑफ जो है सर, ये जब हम ट्रेडमार्क्स एक्ट देखते हैं, पासिंग ऑफ और इन्फ्रिंजमेंट ऑन द बेसिस ऑफ रजिस्टर्ड ट्रेडमार्क, और दूसरा होता है यही प्रेयर यूज या पासिंग ऑफ पर। तो लेजिस्लेचर को क्या जरूरत पड़ी कि ये दो चीजें जो म्यूचुअली कॉन्ट्राडिक्टरी लग रही है, मतलब कॉन्ट्रास्ट में लग रही है, कि एक तरफ से पासिंग ऑफ है तो दूसरी तरफ से डायरेक्ट इन्फ्रिंजमेंट का जो एक्शन प्रोवाइड किया गया है, रजिस्ट्रेशन, इफेक्ट ऑफ रजिस्ट्रेशन का मतलब। सर विजय सर, आई एम क्लियर सर, और आई विल पुट माय क्वेश्चन ब्रीफली नाउ।
नहीं सर, आपकी बिल्कुल, योर क्वेश्चन इज वेरी क्लियर टू मी.
हाँ हाँ
थैंक यू सो मच पीरजादा साहब.
या थैंक
बड़ा
यू
अच्छा
प्लीज.
क्वेश्चन है आपका. और आपका जैसा मैं देख सकता हूँ मैट लॉ आपने रजिस्टर्ड भी करा रखा है. तो
यस सर, ये मैंने
आप
ऐसे
तो
अच्छा लगता है सर.
हाँ
ये मेरी
बिल्कुल.
अपनी क्रिएशन मेरी अपनी है खैर, लेकिन अपनी तो नहीं है सर.
जी.
आई
सर
नो.
देखिए, जी जी,
हाँ सर. यस प्लीज कंटिन्यू.
देखिए लेजिस्लेशन को क्यों जरूरत पड़ी एक्शन ऑफ इन्फ्रिंजमेंट और पासिंग ऑफ की. जैसे मैंने एक एग्जांपल शेयर किया आपके साथ, रजनीगंधा का या दूसरा ब्रांड. ठीक है, कितने सारे ऐसे ब्रांड हैं आज भी इंडिया में ही नहीं, बहुत जगह पर, जो कि एक पर्टिकुलर पॉकेट्स में उस ब्रांड से ट्रेड की जा रही है. ट्रेडर उसको सालों से, उसकी फैमिली जनरेशन से यूज कर रही है, और दैट इज नॉट प्रोटेक्टेड. और जब कोई थर्ड पर्सन उसको देखता है या किसको पता चलता है, और उसको वो ट्रेडमार्क में रजिस्टर्ड करा लेता है, और उस पर्टिकुलर अनरजिस्टर्ड ब्रांड की गुडविल तो है, that may be specific to that particular area or pocket, maybe in some state or some district, लेकिन नेशनल लेवल पर नहीं है. तो बट ओरिजिनल प्रायर यूजर तो वही है उस पर्टिकुलर प्रोडक्ट से रिलेटेड. अब सपोज करिए आपके यहाँ केसर से रिलेटेड, या आपके यहाँ जो कारपेट से रिलेटेड, या दूसरा वुड्स के कोई प्रोडक्ट है, कोई ब्रांड है, उनको अपनी कोई कारीगरी है और स्पेशलिटी है उनकी, उसके लिए उसको वो ट्रेड कर रहे हैं, लेकिन ट्रेडमार्क रजिस्ट्रेशन नहीं कराया. तो क्या वो अपने ब्रांड को प्रोटेक्ट कर सकते हैं? तो जस्ट टू डिस्टिंग्विश के द डिफरेंस बिटवीन रजिस्टर्ड ब्रांड एंड अनरजिस्टर्ड ब्रांड. रजिस्टर्ड ब्रांड में यू नो कि वंस द ट्रेडमार्क इज रजिस्टर्ड, every details concerning the use of that brand, product of associated with that brand, or maybe the goodwill is available with the government record. Even at least a certificate is available where it is established that this particular application was filed or the trademark was filed on particular dates. Even the owner or the applicant failed to prove कि prior user, if I am filing a trademark application today on 4th Feb, and I'm claiming my user date maybe of 10 years back or 5 years back or 2 years back, but in future if there would be any litigation, my mark is registered, and there is some litigation from any third party that they are the prior user, then the government certificate, registration certificate will be helpful for me, because this is registered and certificate is issued by the government. It was published, it was open to the public to oppose that mark, and there was no opposition during that publication period. तो दो ट्रेडमार्क रजिस्टर्ड है या एक ट्रेडमार्क रजिस्टर्ड है, दो लोगों ने सेम ट्रेड करा लिया, रजिस्टर्ड करा लिया, तो एक्शन ऑफ इन्फ्रिंजमेंट तो ही रहा है. बट मैंने रजिस्टर्ड नहीं कराया और मेरे को अपने मार्क को प्रोटेक्ट करना है, तो इसको डिस्टिंग्विश के व्हाट इज द रजिस्टर्ड मार्क, प्रोटेक्शन फॉर द रजिस्टर्ड मार्क एंड प्रोटेक्शन फॉर ए अनरजिस्टर्ड मार्क. तो दिस इज आई थिंक मियरली सिग्निफाइज कि एक्शन ऑफ पासिंग इज ऑफ मींस दिस एक्शन इज इनिशिएटेड बाय ए ओनर of unregistered trademark, because the rights are granted based on the prior user and the goodwill in the purchasing public. आपको ये पता होगा कि यहाँ इंडिया के ट्रेडमार्क रजिस्टर्ड में, जब अभी तो जो ऑनलाइन है, हमारे पास सर्च में पहले अवेलेबल ही नहीं होते. इवन जो रजिस्ट्रार, जो एग्जामिनर सर्च करते थे रजिस्ट्रेशन के लिए, जो एप्लीकेशन को एग्जामिन करते थे, तो उनके पास डेटाबेस ही नहीं था उस तरह का डिजिटाइज. उन्होंने देखा कुछ एक जो इनके रजिस्टर में रहते हैं मैनुअली, उनमें देखा इस क्लास में तो इस तरह का नाम नहीं है. तो आज की डेट में सेम नाम, देयर आर मल्टीपल ओनर्स ऑफ दैट विद द सेम XYZ नेम, क्योंकि वो डेटा नहीं था. लेकिन उनको क्या हटाया जा सकता था? बिकॉज बाय द यूज ऑफ दैट ट्रेडमार्क ड्यूरिंग ए पीरियड ऑफ टाइम, वो उनको भी एक गुडविल हो गई, उनकी भी रेपुटेशन हो गई, तो लॉ ऑफ लिमिटेशन आ गया. उसके बाद उनको, क्योंकि वो उनका कंटिन्यूअस यूज है, तो कोई उसमें एक्शन उनको रिमूव ही नहीं किया जा सकता. लेकिन अभी क्योंकि डेटा डिजिटाइजेशन हो गया, एवरी डेटा इज अवेलेबल, एवरी ट्रेडमार्क इज अवेलेबल. अब तो ROC का भी उसको लिंक कर रहे हैं. तो बेसिक डिफरेंस इसकी लेजिस्लेशन को जरूरत ये पड़ी कि पासिंग ऑफ का, कि जस्ट टू डिस्टिंग्विश दिस एक्शन इज इनिशिएटेड बाय ए ओनर ऑफ अनरजिस्टर्ड ट्रेडमार्क अगेंस्ट मे बी द ओनर ऑफ रजिस्टर ट्रेडमार्क, जिसने बाद में करा लिया या नहीं कराया, बट दिस एक्शन इज इनिशिएटेड बाय ए ओनर ऑफ अनरजिस्टर्ड ट्रेडमार्क।
तो हाँ सर, थैंक यू सर। इसके साथ ही एक क्वेश्चन रिलेटेड है। अब इंटरिम में क्या मिल सकता है सर? ऐसी सिचुएशन में, ऐसी स्थिति में क्या इंटरिम मेजर्स कोर्ट की तरफ से हो सकते हैं?
देखिए,
हम अनरजिस्टर्ड को यस इंजेक्शन दे सकते हैं या नहीं दे सकते?
सर देखिए, कोर्ट के सामने दो चीजें होती हैं, एक तो होता है प्रायर यूजर एंड दूसरा होता है गुडविल ऑफ दैट मार्क। इवन अगर मैं प्रायर यूजर हूं, लेकिन मेरे लेटर यूजर जो मेरे पास आया, हमारे जैसे इस मैटर में एक में ऐसा ये चीजें वो भी बहुत वेटेज रखती है, उसने ये प्रूव कर दिया सर कि चलो ये मेरे से 4 साल पहले के हैं, बट इनके टर्नओवर, बिजनेस टर्नओवर इज वेरी फ्यू, वो भी नॉट 10% ऑफ माय टर्नओवर। दिस मीन्स आई एम हैविंग ग्रेटर रिकॉग्निशन among the trade, among the purchasing public, and the purchasing public of buyer relate this particular trademark to my brand, because मेरे टर्नओवर ज्यादा है, इसका मतलब मेरे जो प्रोडक्ट है दैट इज हैविंग ग्रेटर एक्सेप्टेबिलिटी, तो आई एम एंटाइटल्ड फॉर दिस। तो उस केस में उसको ट्रेडमार्क को उसको इंजंक्शन नहीं मिल सकता।
अच्छा, मतलब बैलेंस ऑफ कन्वीनियंस की फार्मूला पर।
यस, दैट इज आल्सो वेरी नेसेसरी।
Sir, we have another question. It is an in-call message by, yes, so it is an in-call message by Miss Soleha Muhyiddin. She wants to ask, what would be the penalty if my trademark is infringed by any person without my consent?
अच्छा क्वेश्चन है। देखिए, इंडिया में अभी क्या होता है केसेस में, देयर इज ए ग्रॉस इन्फ्रिंजमेंट बाय द इन्फ्रिंजर ऑफ ट्रेडमार्क। हम कोर्ट जाते हैं, कोर्ट में हमें इंजंक्शन मिल जाता है कि भाई दूसरी पार्टी को रोक दिया जाता है, जो भी उसके पास मटेरियल है उससे रिलेटेड या जो प्रोडक्ट है या पैकेजिंग है उसको ओरिजिनल ओनर को हवाले कर दे। वो उसकी प्रेयर में होता है क्या क्या चाहिए। इसके अलावा डैमेजेस के केस में, डैमेजेस इंडिया में बहुत कम अलाउ किए जाते हैं, डैमेजेस गल्फ कंट्रीज में बहुत अलाउ किए जाते हैं, डैमेजेस यूएस में बहुत अलाउ किए जाते हैं, बट इंडिया में यही आपको डैमेजेस हैं कि अगर आपके दूसरे को ट्रेडमार्क यूज करने से स्टॉप कर दिया तो, और आपके ट्रेडमार्क प्रोटेक्शन को मान लिया, ये सबसे बड़ा बेनिफिट है, ये डैमेजेस है। द अदर थिंग, यू कैन आस्क द इन्फ्रिंजर, यू कैन रिक्वेस्ट विद द कोर्ट कि सर इनके वो फाइनेंशियल्स लेके आए हमारे पास, बुक्स एंड अकाउंट्स, उसमें हम देखेंगे कि हमारे इस पर्टिकुलर मेरे रिलेटेड ब्रांड की कितनी टर्नओवर रहे, एंड आई क्लेम 70% ऑफ डैमेजेस आउट ऑफ दैट, इसकी जो प्रॉफिट है, देन कोर्ट कैन डिसाइड कि वो क्या आपको डैमेजेस। बट जनरली बहुत रेयर केसेस में क्या होता है, 90+ केसेस में, 90% प्लस केसेस में, कि एक आप जाते हैं कोर्ट में कि मेरा ट्रेडमार्क इन्फ्रिंज हो रहा है, दूसरा बोलता है, पहले तो कहता जी मेरा है, ठीक है ना, अब उसको लगता है कि कोर्ट में वो क्लेम पूरा नहीं कर पाता, कह रहा सर आई एम इनोसेंट इन्फ्रिंजर, आई वाज नॉट अवेयर ऑफ दैट। देखिए सर, मैंने तो ट्रेडमार्क ऑफिस में फाइल किया है, ट्रेडमार्क रजिस्ट्रार इज द ग्रेटेस्ट अथॉरिटी टू चेक वेदर आई एम एंटाइटल्ड फॉर दिस रजिस्ट्रेशन और नॉट, उसने अलाउ किया है, मेरा मार्क पब्लिश हुआ उसमें, तो आई एम नॉट एट फॉल्ट, ओके इनका है, आई स्टॉप यूजिंग दिस। तो और दूसरा, आपने उसने रजिस्टर्ड भी करा लिया, तो रजिस्टर्ड ट्रेडमार्क के कैंसिलेशन के लिए आप रेक्टिफिकेशन प्रोसीडिंग्स इनिशिएट कर सकते हैं, इसको रेक्टिफाई किया जाए या नहीं रिमूव किया जाए। तो मैडम, ये जो डैमेजेस के केस में यू कैन क्लेम कि आपको पता है कि उसने क्या बिजनेस प्रॉफिट किया हुआ, उसका 70% आप क्लेम कर सकते हैं, 100% कर सकते हैं, विद पेनल्टी आपकी गुडविल को डैमेज किया है, ठीक है, उसने खराब प्रोडक्ट बेचा, डुप्लीकेट प्रोडक्ट बेचा और आपकी गुडविल को इनकेस किया है, तो क्लेम कुछ भी करे, कोर्ट इतना अलाउ नहीं करता।
All right, sir. I think that substantially answers this question as well. And at the end, on behalf of the entire team of Codecast, I would like to thank you for such a well-rounded and congratulate you as well for such a well-rounded lecture and introduction to intellectual property rights, especially, sir, the part where you made such a beautiful presentation. And with the aid of the presentation, we have had our first lecture today. So I want to congratulate you for that as well, sir. And the meticulousness of your presentation was reflected when we saw our own poster included in your own your presentation. So this clearly reflects, sir, the kind of thought you have put behind preparing for the lecture, and we, with utmost gratitude, we thank you for that. And we hope that we call you once again for this lecture. We have the honor of having you on our lecture series. Thanks once again from the entire team, sir, and thanks to all the participants who participated in today's discussion. And I believe most of us would make good use of the valuable information and knowledge that we have gained from your experience and knowledge, sir. Thanks a lot.
Thank you so much, Mr. Malik. And I will also share the presentation with you over WhatsApp, so you can share
Yes,
the same
sure.
with your colleague.
Sure.
And if there would be anything further, I am always available to answer
All
that. Thank you
It will
so
be
much.
our pleasure, sir. Highly
Thank you.
welcome, sir. Thank you.